Court of Appeal sitting in Abuja, Owerri Division Court of Appeal sitting in Abuja, this past week made a critical declaration on Section 84, subsection 12 of the Electoral Act 2022. In a judgment on Wednesday in Abuja, a three-member panel of the court, headed by Justice Ama Akawu Baka, held that the Federal High Court Umuahia had no jurisdiction to have entertained the case because the plaintiff, Nduka Edede, lacked the local standing to have filed the suit in the first place. It further held that the plaintiff did not establish any cause of action to have warranted approaching the court on the issue because of failure to establish that it was directly affected by the provision. The Court of Appeal therefore proceeded to strike out the suit. While determining the appeal on merit, the Appellate Court, however, held that the provision is unconstitutional because it violates Section 42 of the Constitution and denied a class of Nigerian citizens their right to participate in elections. Joining us now to share his thoughts on this matter is a lawyer, senior advocate of Nigeria, Femi Falana. Femi Falana, SAN, welcome to the program.
Thank you very much.
Thank you very much for joining us here on Arise News. And on one of those unusual occasions, you are right here in the studio. I like
well,
that.
because COVID-19 is, relieving some of us of the burden that was imposed a few months ago.
It's good to have you here. So let's start with the major substance of my introduction. The ruling of the Owerri Division of the Court of Appeal sitting in Abuja in the appeal case PDP versus Ekede, right? Edede, Chief Edede. And the court ruled, and that ruling has been very controversial. The media has been saying, the court has declared this Section 8412 unconstitutional, and that amounts to a vindication, victory for President Muhammadu Buhari, who had previously objected to Section 8412. And the court in Umuahia, the Federal High Court. But this same court, speaking from both sides of the mouth, it will appear, raised issues about jurisdiction, which is the fundament of the law, and also about locus standi. So please, what exactly is the truth in this matter?
Well, I think what the Court of Appeal did was to examine the case before it. And at the end of the day, it came to the conclusion that the Umuahia Judicial Division of the Federal High Court ought not to have entertained the case because it has no jurisdiction. The guy who approached the court, Edede, had no local standi. In other words, since it's not affected by that section, this business of fighting for your right through proxies shouldn't be allowed. Whereas a case was filed in Ibadan, the Judicial Division of the Federal Court, the court in Ibadan said, you have no local standi. The man that approached the court. The same forces rushed to Umuahia, and without disclosing to the court, we have lost in Ibadan. The same Attorney General, who was the defendant in both cases, allowed the court in Umuahia to proceed in a way that conflicting decisions were delivered. And so, when the Court of Appeal has done this time, what is your local standard, Mr. Edede? Why are you not allowing those who are affected to approach the court? Therefore, you have no local standard, the court has no jurisdiction. The court then, by the way, what you might call playing courier, it was not before the court. However, this is our view about Section 84, subsection 12. But as far as the law is concerned, I've struck out a case. I've said the court has no local standard. The Court of Appeal cannot now turn around and say, that section is illegal. As far as the law is concerned, it was not before it. But what the Court of Appeal did, in case this matter goes to the Supreme Court, the Supreme Court might want to know our position on this matter. And that was why the court made that passing comment. It has nothing to do with the substance of the decision. Because once a case is struck out, no other can be made thereafter. So the Court of Appeal cannot be said to have now ruled that that section is illegal. Otherwise, President Muhammadu Buhari would not have ordered his ministers who are interested in politics to quit the government. And that's what has happened. In many of the states, the APC governors, right, have ordered, directed those who are interested in politics to quit. Because the whole essence is about the political morality of the government. Ministers and political appointees are to serve the interests of the generality of Nigerians. So if you are aligned politically, like, there is no way you can remain in office. I mean, say for instance, you are the Attorney General of a country, and you are prosecuting people on behalf of the government in the public interest. You are now a politician. So you are now going to use the law to favor your political ally. And that is what the law is saying. Okay,
I'll come to that. But do you think that there are lessons that the Judex, should learn from this? With due respect.
Sure.
Justice Baka, right, his lordship, in preparing the lead judgment in the matter, started with Obita.
You see, again...
And he made it sound like it was declaratory. If we're doing a judicial review. I thought that the basic structure of a judgment would be that you deal with the matter before the court. Before the court will now begin to speak Obita. But it's like his lordship, with due respect, upturned the process.
I fully agree with you. What a court does, or what courts do all the time, is to decide the matter before you. You then strike out a case for want of local standing, for lack of jurisdiction. You might then say in passing, this is our view. But we have already dismissed this case. We have struck it out. And that is the end of the matter. So I think, particularly for political cases, our courts will have to be more circumspect. And lawyers to have a duty to help the courts. If a court in Abuja, if a court in Ibadan have thrown out a case for lack of local standard, you don't rush to Umuahia and get a favorable order and then announce, we are going to comply with the judgment of the Umuahia, the federal court in Umuahia, as if you are choosing and picking. Whereas before then, in the case filed by PDP against the Attorney General, the President, and the National Assembly, the court had restrained the government from implementing Section 84, subsection 12. You now rush to, you are now shopping for orders. So when you do this, you are making a mockery of the judicial system, and you are exposing the court to ridicule. Particularly when you have conflicting court orders. The members of the public would then wonder which of these orders, should be obeyed or not obeyed. And we must not reduce the judiciary to that level. When you do that, you erode the integrity of the courts. And you make people to believe that these courts are not independent. And it's a dangerous phenomenon. And the government should not be associated with such manipulation of the judicial system, which is what the former Attorney General, Mr. Abubakar Malami SAN, has been accused of.
Where do you say the former Attorney General?
No, he ceased to be Attorney General since Friday.
No. He says he never resigned.
No, it's not what he says.
And Chris Ngige, senator, also said he did not resign.
No, you see,
that brings us to another issue, because you went out there and you say, no, the two of them have already sacked themselves. And they say, no, they did not resign.
You see, it's not what they are saying. Because what they are doing now reminds one of what we call sit-tight ministers of the First Republic. I was just being told this morning by a friend of mine, a comment of my journalist, who reminded me that the Daily Times was looking for the best headline on that occasion. When the government of Akintola was sacked. And that the way the Daily Times decided to cast the headline, Akintola Taku. That is what is going on. Now, there are two issues here. There are some ministers who were reported to have resigned in line with the directive of the president. If you are interested in politics, please quit my government. And they resigned. Another group did not resign. But what the president did in his wisdom is to find out from the APC who are among my ministers have submitted declaration of intention or nomination form. And he got a list of 9 of them. The president summoned all of them. Please, can you come to the villa for your send-off ceremony? And they rushed to the villa. At the brief ceremony, the president thanked them for the services rendered to the nation. The president wished them success in their political career and other future, endeavor. Right? And the president announced there, I am going to replace you guys very soon. I am going to announce the replacement of new ministers very soon to replace you. At the ceremony, on behalf of all of them, the 9 of them, Mr. Godwin Akpabio, the former minister, immediate past minister of Niger Delta, thanked the president. On behalf of all of them, I thank you, Mr. President, for giving us the opportunity to serve the nation in various capacities. Now that we are stepping aside, we are going out now, sir. We are going to become your disciples. That was the end of the matter. At the end of the program, the presidency issued a statement to inform Nigerians of the decision of the government to relieve the following 9 people of their ministerial positions. Their names were listed. The last photograph, the farewell picture taken with the president, was published in the media. That is the end. In other words, those who resigned, who sent letters of resignation. I think one professor of law was elected to have said yesterday, oh, the president hasn't accepted. Therefore, that's not, with profound respect, that's not talking law. Section 306 of Section 2 provides that once the letter is delivered and is received, you cease to be a minister. 2, for those who did not submit a letter, the fact that the president invited you without putting any gun on your head to a farewell program, the fact that you participated in the farewell program, the fact that on your behalf, Mr. Godswill Akpabio thanked the president for allowing you to serve, and that, sir, we are on our way out now. We are going to serve your interests. We are going to promote Buharism. Now that we are going out, that is the end of the matter. In other words, if you didn't submit a letter, the president has sacked you. That is the law today. So for you now to say you are parading yourself, Dr. Abacha, I want to believe that these fellows are aware that they are out. But I think they have up to tomorrow. Hence, in the release, in the statement by the presidency, they were referred to as outgoing ministers, the 9 of them, including Mr. Abubakar Malami SN and Dr. Chris Ngige. You know, Dr. Chris Ngige, even with profound respect, arrogantly said, a day before the valedictory ceremony, the president will have to define for me what he means by resignation. That is the Minister of Labor. I mean, that was the Minister of Labor of Nigeria, saying that he didn't understand, a medical doctor, they didn't understand what resignation means. But I think somebody should have directed his attention to Section 306 of Section 2 of the Constitution.
Well, but in fairness to Senator Chris Ngige, he says this resignation that you talk about is a figment of your imagination.
No,
he put a statement out there. He said what he
didn't resign.
No, he said what he said is that he will consult.
He will consult the president.
The president and also his constituents.
His constituency did not. He wasn't appointed the minister by his constituency. The man who appointed him a minister has sacked him by bringing him to a farewell ceremony. Thank you for serving me. Please, I wish you well in your political career. And if you are no longer contesting the presidency, I wish you success in your future endeavors. What do you want? And on his behalf, and on behalf of others.
No, I want us to be fair.
To be fair to who?
No, it's the president who has the powers to hire and fire.
He has fired.
So, no, if the ministers...
By conduct.
Now, if the ministers now say we are not going anywhere, We are here.
That is what I mean
then the onus is on the president.
That is what I mean by sit-tight ministers. The president is being embarrassed, and the country is being ridiculed. And we are saying there is also what we call morality. In section 45 of the Constitution, you can't talk of your fundamental human right to remain a minister. It's not a human right to remain a minister. If the man who appointed you has sent you packing in a rather polite way, I think you now want to be embarrassed. We now will expect the presidency to say, sorry, I decided to bid you farewell. What are you talking about? But I want to assume, Dr. Abati, that they still have till tomorrow, since the president gave them a date. And in the speech of the president, mind you, he said, some of you have resigned. I'm expecting the resignation further, in line with my directive. However, I am thanking you for serving the nation meritoriously. And I wish you well, wherever you decide to go. Some two people now say, oh, I'm sorry, I want to lose my 100 million nomination fee. I want to lose my 50 million nomination fee. I no longer want to resign. If you are now applying for those jobs afresh, the president has no discretion on the matter. It's not your voluntary decision to remain a minister at all costs. The president will now have to send your names to the Senate, which is like dissolving a cabinet. If you want to be reappointed, the president will have to invoke section 147 of the Constitution by sending your name nomination to the Senate for a fresh screening.
Okay.
That's the law.
It's good you mentioned this 100 million. Now, the people who pay the 100 million, they say they are willing to lose the 100 million.
But they have lost it.
But you say it's illegal,
no,
unconstitutional
to
start with, and it's immoral to pay 100 million.
Oh, yes, but they have
their money.
No, they have agreed to pay. How do you know it's their money? When you are told that people are contributing for them. No, because they could not own up that we are paying 100 million naira to buy a farm. They then gather people to pay on their behalf. So, but they are saying, we are losing the money. The man, Mr. Abubakar Salami, now said, I don't want to be a governor again. I lose my nomination fee. Dr. Chris Ngigi said, I don't want to be a president again. I don't want to be the president of Nigeria. I lose my 100 million. And the money will have to go to the... Of course, it's supposed to go to the political party. But the EFCC is already investigating.
But is it constitutional? Is it legal?
No,
to pay 100 million, 40 million?
I had said it before now, publicly, that it is illegal to impose the sum of 100 million or 40 million on aspirants, for a purpose, according to them, to wield out and to discourage those who may just want to populate, the process. No, that's not the way the Constitution is framed. The Constitution is saying you shall not exclude anybody on the ground of fortune, class, ideology, or sex.
Section 40. Section
42. Article 2 of the African Charter has also prohibited discrimination. And Article 13 of the African Charter on Human and People's Rights Act provides that every African, every Nigerian shall have equal access to the government of his country, either to contest election or through people. So the government shall be so formed. But to now say, in order to discourage people, including retired professors, including retired judges and others, whose pension is not paid, you now say, sorry, since you cannot mobilize 100 million, we cannot have your services at the highest level in our country. It is immoral. Because in the country today, the minimum wage is 30,000 naira. So you cannot ask aspirants to pay 100 million or 40 million, which is why these gentlemen, including some of them who are assumed to be billionaires, are now saying, please, we can't raise the money ourselves. So the money is being raised for us. Because they can't justify before Nigerians that you are paying 100 million or 40 million to buy a farm. So, but they have these guys who bought the farms have now said, we don't need the money. I want to remain a minister because this is a game of chance. I'm not sure I will win that election. So let me remain where I am because I still have about one year, to do what I'm doing. I help myself, So I think that is what is going on. But it's too late in the day because, Ruben, there's what you call estoppel in law.
Yes.
If you make the whole world to believe and the president to believe that you have left the government, you are stopped from turning back to say, sorry, I'm still here. I'm still ready for service.
But I've read some analysis saying, look, this Electoral Act 2022 is a good mine for lawyers. Chop time. Lawyers are going to make a lot of money because there are many contradictions in that law. One contradiction that we had to deal with in the course of the week is Section 84(8). The National Assembly came together, Senate, House of Reps, expeditious consideration to create room for statutory delegates or special delegates, as they are otherwise called. And some people have argued, including civil society organizations, that it's not right. It's going to create more problems. Will it take effect retroactively? Are we changing the goalpost in the middle of the game? And that in any case, if you go further and you look at Section 84(13), there are issues there. If you look at Section 84(3),
there are issues there.
Yeah, but I'll come back to Section 84(3). Let us start with Section 84(8).
No, I would think that what the National Assembly did last week was to address what they have seen as a lacuna, but with profound respect to the members. Like you put it, you can't change the rules in the middle of the game. That will have a futuristic effect. In fact, the bill has not even been sent to the president. So, the bill may be signed after the primaries of the political parties, in which case the National Assembly members will realize that this is almost an exercise in futility. And the president may say, sorry, and he has done it before, I'm not going to sign this bill because it's meant to achieve a purpose for this election. And the process has already commenced. So please put it aside. We will look at it in future. That's the way I would think the president should be advised to approach this matter.
Although he's a beneficiary.
No, it doesn't matter. Because again, as we keep on telling the National Assembly people and the president, laws are supposed to be made for the benefit of the entire country and not to satisfy the interests of some political appointees. However, how highly placed they may be. Because it's dangerous to make laws for the benefit of a few people.
So you agree that the amendment is ad hominem?
No, this particular one, oh yeah, for sure. So they may have to wait until after the election to complete the exercise.
Okay, but there's also 84(3), which I referred to earlier. Section 84(3) is saying, basically, that no political party can impose or, appoint a candidate for an election. That only a court of law can do so. Okay, this sounds very contradictory. On one hand, we talk about party guidelines, and now we say parties cannot, decide on who should be the appropriate candidate. Now, that's another legal landmine.
No.
What it means is that these parties, the screening exercises that they are conducting, if they disqualify anybody, they'll have a plethora of litigations. In the light of that Section 84(3), what do you think?
Now, we have been in this game for some time.
Yeah.
I think in 2007, we saw an executive manipulation of the electoral process to disqualify certain people on the eve of the election. And I think the case of Atiku, and the Attorney General for the Federation was where the Supreme Court decided, right, that political parties cannot disqualify candidates. Even INEC cannot. So that is the position today. In other words, if I want a candidate disqualified, I will have to go to a court where there will be an umpire to look at the reasons adduced for wanting somebody disqualified. And then you must hear the person, a way of granting, him or her fair hearing. So that an independent person can decide, And I think that is what that section is all about. Because in the past, some big, some chieftains or big wigs in the party will make a mockery of primary election and impose candidates. And the court will say, sorry, our hands are tied. That is the internal affair of the party. So that was what the National Assembly said. That is the mischief that the National Assembly set out to kill. Whoever now says, but you know what some of the parties are already doing is to say, knowing the implications of these guidelines, is to say, you have to sign a withdrawal letter in advance.
From 18?
Yeah.
In the APC?
Yeah, and you have to go before a notary public or a commissioner of oath where you would declare on your own. You know the essence of that, what they are planning? Is if you file an action letter to challenge the result of the primary, you then say, you withdrew. This is your letter. I mean, this is your declaration.
By Felix Moka and Senator Abdullahi Adamo, that Form 18 is optional.
Well,
and some of the aspirants have said they did not sign it.
Yeah. Now, but for those who have signed, that's what they are planning. But again, the attitude of the court is to say, you knowingly endorsed these guidelines and you participated in the primary election. We're not going to get involved. We're going to allow the party to decide. And since you have agreed, right, to operate under this draconian guideline, that the business is yours. And that is why the court have now moved away from Section 34 of the old Electoral Act, which allow any member of the public to challenge the nomination of anybody if you have information that was not qualified. The new law has now restricted that to participants and the political party. And what they are now trying to do is for the party, as they are already saying, you cannot go to court. You cannot sue us because you have agreed to operate under this guideline. It's a very dangerous situation. And I do hope that some of them will have the courage, if they are so changed, to be able to go to court. But from what is going on already, right? People are saying, I have lost 100 million naira. I didn't ask anybody to pay on my behalf. So such people are not likely to challenge the actions of the political parties. So that's the way I look at it.
Okay. Before we go, let's start winding down now. What do you think of this public controversy about certain public officials, certain individuals showing interest in the race? Former President Goodluck Jonathan, CBN Governor Godwin Emefiele, Akinwumi Adesina, President of the African Development Bank, whose name has been mentioned as one of those persons who submitted the forms. I've read some of your comments, but are they not within their rights to show interest?
No.
Are the people who have said, no, I did not show interest, it's other people buying forms on my behalf? I have no interest in the matter. It's not my deed. Should we crucify them?
No. I am yet to confirm whether Dr. Adesina of the ADB, African Development Bank, is participating in the primary election of the APC. I will be totally flabbergasted if it is confirmed, because the ethics, the rules of the bank do not seem to allow the president and members of the board and staff of that bank to be so politically exposed. And I'm serious about what their guidelines say. In fact, that bank cannot even give a loan to a politically exposed person. So, again, I don't know how Dr. Adeshina is going to handle that. Because what we read initially was that those who paid on his behalf had not even contacted him.
But he has been very quiet. He has refused to say a word.
You see,
I've even personally sent him WhatsApp messages to say, what are you doing? What's going on? I've not received any response.
So that is what I mean.
So is he playing a game?
No, I am saying that if it is eventually confirmed, there will be a problem. I know that. Two, I want to believe, since it has now been reported that Dr. Goodluck Jonathan did not submit his nomination form. You know, initially he said he distanced himself from the form purchased by the people, they say Almajiris or whatever.
Yes.
You know, and for me,
Almajiri communities and the nomadic pastoralists.
My reaction was that if Almajiris can mobilize 100 million, there won't be Almajiris, you know, but, you know, the former president distanced himself. But later, I understand he was persuaded to accept. And so, it was also reported that he had gone to register in a ward in Bayelsa. But
no, but that's not true.
Yeah. I mean, the last we have now heard is that he didn't submit a nomination form. So I want to believe that he has consulted some lawyers who might have advised him that what you are doing may be problematic.
No, your reading of Section 1373.
No. I disagree with you. No, you don't have to agree with me. You don't have to agree with me. No, you don't have to agree with me.
With Michael Zekona,
you don't know
whose interpretation is more.
You don't have to agree with me. All I'm saying, right? People say, no, it cannot be retrospective. No. In 2003, I think this was the case of Governor Ibori. In 2003, some of his political opponents said he was not qualified to run on the ground that he had been convicted under the military in 1995. If that information had been confirmed, because, you know, the court said whereas he was sentenced, the page on conviction had been removed. So, for that reason, he got out technically. If it had been confirmed, he would have been disqualified retrospectively. But that is there. Since President Jonathan has withdrawn from the race as it were, we don't need to waste time, you know. It becomes academic. With respect to the governor of the central bank, I read yesterday that he has now withdrawn. He's no longer participating in the presidential primary of the APC. I think that's what I read.
Yes, and that people who are criticizing him, they are free to have attacks.
Attack.
Yes, okay, so let's have that attack right now.
Again, I'm sure he will need to consult further. Because as of today, he has a case pending in the Federal Court in Abuja, where he's seeking a declaration that I want to remain the governor of the central bank. At the same time, I want to contest the presidential primary under a party. He didn't name the party.
The rest of the matter is no longer relevant.
No, what do you mean?
The case has
not been withdrawn. Two, another valid and subsisting obtained from the Delta State High Court in Kwale. It's not to the effect. The board of the central bank, you are hereby restrained from preventing Mr. Godwin Emefiele from contesting election, and that he shall only resign a month to the election. Now, you cannot use
Section 66, Section 107, Section 137, Section 182.
Yes, you cannot use a letter, right, to quash a court order. Mind you, two, the sections you are cited are not relevant yet. Section 9 of the Central Bank Act provides that the job of the central bank governor shall be full-time. And if he's going to, and he shall not be engaged in any other vocation, like politics. Politics is a vocation. Even if he's going to be involved in a charitable activity, the board will authorize him. So far, we have not been shown the resolution of the bank allowing him to go and register as a member of a political party in a ward in Delta State. Because we are told, and this has not been denied, that he registered as a member of the APC in February, nowhere in the world, not even in a banana republic, is the governor of a central bank a card-carrying member of a political party. It has very dangerous implications. If you look at the enormous powers of the governor of the central bank. Now, on those who have heart attack, I do hope that Mr. Emefiele will not have a heart attack at the end of the day.
No, let's be fair and balanced. Yeah. He has said he's not involved in all of this.
But he has a court order in his favor. He has a case pending in Abuja. No, he hasn't withdrawn.
No, he has renounced.
Has he withdrawn the case? The cases?
Ozekome is his counsel.
So as
Ozekome will take the consequential action.
No, you are saying...
He cannot act ahead of his client.
No, the client has now said in
I'm
writing,
not involved.
But there are documents in court. There is a court order to the fact that is involved.
No, all of those have become academic.
No, you are saying that. He has not rendered them academic. He has not withdrawn the cases. And in any case, whether he withdraws the cases or not, the fact that he indicated his wish to contest under the APC has disqualified him as the governor of the Central Bank of Nigeria. That office is supposed to be neutral. In the case of Olusegun Angaguan, Olusegun Mimiko, in the case of Attorney General of the Federation and Atiku, the court made it clear that you cannot, as an agency of the government, get involved in politics. You must be neutral.
But can't an individual say, I've changed my mind?
You have to resign. That's the point.
No.
He cannot remain in office. When you are telling the court, sir, please authorize me as the sitting governor of the Central Bank to contest election. And that was refused in Abuja. You now have a court order. And that was the base of that arrogance in saying, no news yet, you will hear news later. All those who are wishing me to resign will have heart attack. And I do hope that somebody else will not have heart attack at the end of the day.
Okay, finally, Femi Falana is saying, let's talk about Aisha Buhari, who has said, look, these political parties should not say they are giving free forms to women, to use that as an excuse to marginalize them further. Because in all the political parties, the women groups have been protesting. That yes, they say they've reduced payment fees for nomination and all of that. But at the same time, they have been put under pressure to concede to male aspirants. How do we address that? Considering the fact that women are just as important as men in the political space in Nigeria and elsewhere, in every other space.
Two issues here. The political system we operate excludes the majority of our people. We just spoke about 100 million. Women are excluded, likely. Youths are excluded. Forget not to run act. Workers are excluded from the political system. So you now have members of the ruling class dominating, controlling the political affairs of our country. What the women have done is to insist that all the legal impediments erected as a stumbling block against the participation of women in politics are removed. The National Assembly says no. I mean, for me, the most ridiculous one was the bill that provides. Whereas, if a man marries a foreigner, the foreigner is entitled to Nigerian citizenship. Allow a Nigerian woman that marries a foreigner to also confer Nigerian citizenship on her husband. They said no. So, and you can look at the other provisions. Whereas, in some other African countries, right, these matters are being seriously addressed to the extent today that a country like Rwanda is ahead of other countries in the world in terms of women inclusion. The national parliament, 63% women control. But you are then told, oh, that country fought a war. Is that the only country that fought a war? Some are telling you, on religious ground, we cannot allow women to play a leading role in politics. And we then refer them to a country like Senegal, which has 43% women representation in the parliament. It's the 7th country in the world. Our own is less than 3%. So we can't go on and on like this. But I also challenge the women to learn from the examples of Mrs. Ransom Kuti, Fela's mother, Sawaba Gambo, Margaret Epo and others, who threw away all these cultural and political barriers and played leading roles in the politics of our country. And their places were reserved, even by the men. But I think our women are getting it right now. And that was why they have occupied the National Assembly. You must revisit the rejection of this bill. Luckily, or by coincidence, the Federal High Court in Abuja, sitting in Abuja, has now granted the reliefs of the women to the effect that in all appointments by the government of Nigeria, 35%, shall be reserved for women. So the question of affirmative action has now become a legal matter. So if any government is formed in Nigeria now, without at least 35% inclusion of women, you can accuse the government of, contempt of court. But happily, the federal government has announced that we are going to comply with the provisions of the judgment. Okay. So the judgment, we just got a certified true copy of the judgment. And so this is going to be sent to the government for compliance.
Well, on that note, I would like to thank you very much, Mr. Femi Falana, SAN, for joining us today on the...